defined as a marriage that's been conducted for the sole purpose of obtaining an immigration advantage. It also relates to civil partnerships of convenience and durable partnerships as well. So the definition is that you've entered into this marriage or durable relationship for the sole purpose of obtaining an immigration advantage in the United Kingdom. So that's the definition of a marriage of convenience. In 2012, there was a case called Papa Georgie, which is the sort of leading case in this area. And in that case, it was a marriage between an EEA national and a non EEA national, and the non EEA national was making an application to come to the United Kingdom on a visit to stay with her husband, who was an EEA national. Now, the relevance of that case is that the upper tribunal confirmed in that authority that the burden of proving that a relationship or a marriage is a sham is on the Secretary of State. So the Secretary of State bears the burden of proving that that a marriage is one of convenience as opposed to a genuine relationship. So that was the first case that dealt with that point quite specifically. I say the first domestic case that dealt with that point specifically, and it's called Papa Georgie, and it was the judgment was handed down by the upper tribunal in 2012. So the courts were told quite clearly that if there is an allegation made by the Secretary of State that this is a marriage of convenience, the Secretary of State bears the burden, so they have to prove that this is a marriage of convenience. Now, in that case, what the court said is that the judge has to look at all the circumstances of the case, so the evidence that the Home Office is relying upon, why they're suspicious of the relationship, and also the evidence provided by the parties to deal with the allegation that's made. So any evidence that they live together and how they respond to any questions put to them in oral evidence. So those are all the issues that the judge has to look at and then come to a decision. And the question for the judge is, having regard to all of these factors, is it more probable than not that this is a marriage of convenience? So that was, as I say, the first case in which that issue was dealt with in some detail in 2012. I would say that the next relevant case was one that was before the Court of Appeal. It's called Agbo, and I was actually involved in that case. It was relevant, or it is relevant, because again the Court of Appeal, the courts reiterated that the burden of proof in these types of cases is on the Secretary of State. So it's not for an applicant to say, I'm not in a marriage of convenience, in effect asking them to prove a negative. The Secretary of State may have a suspicion that this is a sham or that this is not a genuine relationship or a marriage of convenience, but they have to prove it, and it's not sufficient to say this is why we suspect that your marriage is not genuine. They have to actually essentially prove their case. So he who asserts must prove, essentially, is how the courts must approach this kind of allegation. A Nigerian national had made an application for a residence card. You have a residence card, of course, in the United Kingdom to reflect your right to reside as a family member of an EEA national. He was married to a French national and they lived together in the United Kingdom. He made an application for a residence card to reflect his right to reside, and with the application he provided what's required, which is proof of the EEA national's status in the UK, so that she was working, that she was exercising treaty rights, evidence that they were living together, evidence of their marriage, and any additional sort of pictures of their wedding to show that they were genuinely married and so forth. So that evidence was submitted to the Secretary of State for the residence card application. Prior to the application being considered and determined by the Secretary of State, they decided to carry out an enforcement visit. So they went to Mr. Agbo's house. Unfortunately, neither himself nor his wife were at home and they met an occupant of the property who was actually visiting. She didn't live there, and they asked her a series of questions. They said, "You know this couple? What do you know about them? Do they live together?" And then she said quite candidly, "I don't know them. I'm just visiting this property. I don't really live here." The enforcement officers, they left some details for Mr. Agbo to get in touch with them. He did so, but there was no follow-up. So there was no invitation to the couple to actually come in and be interviewed by the Home Office. They just refused the application. The Secretary of State didn't serve any evidence with the refusal, so it didn't say why they suspected that this was a marriage of convenience. They kind of referred to the fact that, we came to your house, you weren't there, we asked some woman about you, and she said she didn't know you. There were some other issues involved, but the main issue was that they'd spoken to this woman and she didn't know them, even though she was supposedly living in the house. But again, it was made clear by the woman that she didn't live there and she was visiting. On the day of the hearing, despite numerous requests for documentary evidence to support the Secretary of State's case, on the day of the hearing, I actually attended the first tier tribunal hearing, and I was presented with officers' notes of this enforcement visit. Unsigned, not very detailed, sort of very sketchy as to the details of who they spoke to, what the person said. The evidence was not strong, and I asked my client whether or not he wanted to adjourn. He decided to go ahead. The judge concluded that on the evidence he had before him, that the allegation had been made out, it was substantiated, and this was a marriage of convenience. At that stage, Mr. Agbo and his wife, their relationship had broken down, so she hadn't attended the hearing. So the matter went all the way to the Court of Appeal, and the Court of Appeal said quite clearly that in cases such as this, any evidence that's being relied upon by the Secretary of State must be served in advance, so that the parties have an opportunity to deal with any allegation made by the Secretary of State. So if it's a witness statement from an officer, that should be served in advance, and any interview record should be disclosed to the appellant prior to the hearing, so that all the evidence can be considered by the other party so that they can deal with any allegations. Court of Appeal also said that it's not enough for the Secretary of State to reasonably suspect that it's a marriage of convenience. They have to prove that it is, or the person who's making an application for a residence card is disqualified from getting a residence card because it's a sham marriage, but that has to be proved by the Secretary of State. So that's why Agbo is relevant. After Agbo, there was Rosa, which again reiterated the same principle. Secretary of State must prove that a relationship is not genuine, or that this is a marriage of convenience or a civil partnership of convenience. And it's not enough for them to say interview you and you make some mistakes during the interview. There has to be more than that, essentially. It's whether it's more probable than not, notwithstanding what you said in the interview, that this is a false marriage or a marriage of convenience. In the case of Sadowska, which was the judgment was handed down by the upper tribunal in 2017, at the latter part of the year, the Supreme Court gave some guidance to courts, the lower courts, and in that judgment, it's a very short judgment, helpfully, it says, it talks about two different aspects. Again, this was an appeal from the first tier that went all the way to the Supreme Court that was sitting in Scotland. And in the first tier tribunal, unfortunately, the immigration judge said that it was the appellant who had to prove that this was not a marriage of convenience, when clearly in all the authorities and all the guidance and in EU directive, it's clear that it's the Secretary of State that bears the burden. Well, since 2015, the Secretary of State has a referral scheme in which if you are a couple and you're planning to get married and you happen to be a non EEA national that has limited leave in the UK, so you're a student or a worker, or you don't have any leave at all, so you're an overstayer, and you're marrying an EEA national, an EU national, the registrar is obliged to refer your notification of marriage to the Home Office. So the registrar has to tell the Home Office that this couple is getting married. I've noted that the Non EEA national has no leave, they're an overstayer, or they have limited leave, and the other party or the other couple is an EU national. So what the Home Office can do is either invite the couple to be interviewed at one of their offices, one of the immigration offices, and what happens in those circumstances is that the couple will be asked to come in, they'll be asked a number of questions separately. If an interpreter is needed, that will be provided, and usually those questions run up to about 200. They last for a couple of hours. It's a Mr. and Mrs. kind of situation where they'll ask each party, do you know your husband or wife's favourite colour, what part of the house, what side of the bed do they sleep on, things that they expect a couple to know about each other. They'll ask about family members, so what are your parents' details, what their names, where they live, your siblings' details as well, how many brothers and sisters do you have, where do they live, what are their circumstances, and these are things they expect a couple to know about each other. The other way that the Home Office investigates a couple's circumstances is by carrying out an enforcement visit or a pastoral visit, as it's referred to sometimes in documents, which is where they come to your house. So they do a spot check. If you say you live together, they expect you to be at home, or at the very least there should be evidence that you live together so it's 5 or 6 o'clock in the morning. They might come to your house and see whether you're actually living together. So that's the other way that they investigate your relationship. Now, if it's concluded on the basis of either an interview that's been conducted, because maybe there were inconsistencies in the way that you answered questions and your responses, so you didn't know certain things that they would have thought you'd know about your partner, or they carry out a pastoral visit and perhaps you're not home, but there's no evidence that you actually live in the property with your partner, they would then refuse the application. What would be helpful, I think, in those cases is if they have a system by which they say to you, they write to you and say, look, we've noted these matters and we think you may have conducted a marriage of convenience, so could you respond? But they don't do that. They usually just refuse your application and then give you an in-country right of appeal. In those circumstances, I would advise that you instruct a solicitor or indeed get some legal advice about your circumstances. Make sure that you have any document that's relied upon by the Home Office, and that's by requesting any documents from the Home Office. So your interview record for both parties should be disclosed, or any officer's notes from the pastoral visit. So what officers usually do is they have a notepad and they write down any questions they asked to whoever they spoke to, or they make notes of whatever they observed. So if they saw that they went to a room and this is supposed to be your bedroom and they don't see any evidence that you live there, they have to note those things down, and you would want to see the officer's notes. So you ask for those things well before the hearing. I have had many cases where the Home Office don't disclose that material for whatever reason. Sometimes it's sensitive material that they don't want to disclose. Perhaps they have to redact some of or remove some of the information that's in the report. So it takes a while for that evidence to be submitted. I have had many hearings where we've gone to court and that's where that evidence is supplied, which is not the best approach because it's very prejudicial to the client. They need to know what the case is against them so they can deal with that appropriately rather than being sort of ambushed with material that they wouldn't have seen previously. So I would say find out what the case is against you in clear terms. So get the transcript, get the officer's notes, and then if you don't get it before the hearing, try and ask for an adjournment so that material can be supplied. If it is submitted on the day of the hearing, try and get the judge to exclude that evidence because it should have been served in accordance with the procedure rules. If that is not excluded, then you can ask for an adjournment, or if it's something you can deal with in evidence, then of course you can try and deal with that during the hearing. And I'm sure you'll hopefully have experienced counsel or a solicitor who will guide you through the law, which is that the Secretary of State have to prove their case and they bear the burden, but also anything you said can be explained during the hearing. So the judge is an impartial party who will listen to all the evidence that you provide and any explanations you have for mistakes perhaps that could have taken place during the interview or the enforcement visit. So that's what I would advise parties to do if they are faced with such an allegation. I would always say photographs of you as a couple, and not just from your wedding, but spending time together, going to parties, seeing friends if you're a social couple, or just photographs of family members. So if you have met each other's family members, then of course that would be helpful to show. Documents such as letters of support, saying, we spend time with them as a couple, we know them, we've known them for a period of time, we know they're a genuine couple. And if you can get your witnesses to come to court to be cross-examined, to confirm that they know you as a couple, that's going to be helpful as well. Evidence of joint responsibility, so if you're both paying council tax, if you're both paying utility bills in your property, evidence of cohabitation would have been sent with any application made by the Non EEA national. So you'd expect there to be evidence of cohabitation. But if you have joint responsibilities, it would be very important to put those before the first tier tribunal, particularly, to say, look, we don't just live together, we have shared responsibility. In cases where there are children, it should be obvious to the Secretary of State that it's a genuine relationship. But again, I have had a few cases where, one in particular which was quite interesting, where the couple didn't live together, but they had a child, and there was evidence that they spent time together as a family. So there were lots of pictures of them going to the zoo and visiting other relatives in the UK, cousins, having birthday parties. So it's clearly a genuine relationship, it's just that they didn't live together. So that was a slightly unusual one. But anything showing that you are a genuine couple, that you do spend time together and you intend to live together in this country together, that's what you need to put before the first tier tribunal in particular and the immigration courts. The funniest one, it usually involves children. The courts don't necessarily allow small children to come into the courtroom because they can be quite disruptive, because of course it's a lovely large room that's spacious and they want to run around. I had a case with a young lady who was still breastfeeding, but her daughter she was about 2, so she was very late in the breastfeeding. And the judge, who was a sort of old, lovely man, who was very uncomfortable with the fact that this young daughter was running around, and it was slightly distracting, but he was very amused, and it lightened what otherwise would have been quite a difficult, I think, hearing for the client, because she was talking about luckily it wasn't a torture claim or an asylum matter, but there were potentially some issues that would have been quite painful to discuss. But because her daughter was very happily running about, it lightened the mood. So it's always pleasant. Sometimes it can be very distracting, but it's nice when little children are cute and they're running around in the courtroom, and the judge is trying to be professional, but is clearly slightly disrupted by this small person running around. So yeah, that's happened. I am Nwamaka Nnamani of Augustus Chambers, and you have been watching Legal Pepper Soup by OJ and Solicitors. Thank you for watching.